Well, I'm really pleased to come today, and I'll just plunge right in. In terms of what I'm going to cover today, the first part of my presentation will deal with legal principles dealing with insurance disability claims. The second part will be different perspectives, insurance versus medical, because there's communication issues that can come up in that setting. And if you understand some of those challenges, I think you'll be a more effective communicator with insurance companies. And the third is tackling tough issues, things like pain, fatigue, depression, anxiety, things that are invisible disabilities. How do you deal with them? And the last piece is tips and strategies on how you can communicate more effectively if you are asked by patients, for example, to deal with their disability insurance claims. So the legal principle that governs insurance law is based on good faith. Insurance policies, the law says, are contracts of utmost good faith. When a claim is made, the insurance companies are under a duty to investigate fairly, look at all of the evidence, to adjudicate fairly, balance it in a reasonable way, and then pay if there's no credible reason to withhold benefits. The reason for the good faith is because you have such a power imbalance between a powerful insurance company on one side and somebody who is sick and can't work on the other side. So the court says, look, insurance company, you've got to behave in a way that reflects good faith. What the courts have said, and this is a Supreme Court of Canada decision, actually one that I took to the court, the duty of good faith requires an insurer to deal with its insured claim fairly. The duty to act fairly applies both to the manner in which the insurer investigates and assesses the claim and to the decision whether or not to pay. In making a decision whether to refuse payment, an insurer must assess the merits of the claim in a balanced and reasonable manner. So it's just asking for fairness, expecting fairness. What does totally disabled mean? That sounds like it's somebody who can't get out of bed, but it's not. In another Supreme Court of Canada decision, the court said the test of total disability is satisfied when the circumstances are such that a reasonable, this is an old case, so it's all man, would recognize that he should not engage in certain activity, although he is literally not physically unable to do so. Now, in that case, it was an insurance broker. He could answer the phone, he could make notes, he could do specific things, but when it came to running his business, he fell apart. So he was considered to be totally disabled because he couldn't actually do his job. And the court said there's total disability if the insured's injuries or illness is such that common care and prudence require him to desist in order to effectuate a cure. So, you take the time you need in order to get better. The totally disabled, I should also say, there are often two portions. One is an ONOC, the other is an ENEOC. And so the definitions have to be looked at based on what the policies actually say. Another important piece is what is the standard of proof? Now, the standard of proof is whether it is more likely than not that a person is disabled. And I think insurance companies, in my experience questioning adjudicators, is that they're not particularly taught that. They have to be completely pretty much convinced that a person is disabled before they're willing to pay. But that is not the legal standard. The legal standard is it more likely than not that they're unable to work? And if so, they would be, under our civil law, entitled to benefits. Another thing to look at is that all insurance policies give the insurer the right to require the insured, the patient, to undergo an examination. Now, sometimes it's just a doctor, sometimes it can be broader, any healthcare provider, but the insurance company has that right, and it's there to allow them to address situations where they're not clear. And that'll come up later on. Another key portion of disability insurance policies is that individuals have to remain under the care of a physician. And sometimes the care also means that they have to comply with certain treatments recommended by their doctor. This is often a challenge for doctors who have disability policies and disability claims because they don't like going to see another doctor, and but they do need to under the terms of the policy. Another interesting and relevant to return to work provision in insurance policies is the rehabilitation provision, and these policies don't often stipulate whether you're dealing with medical rehab or voc rehab, and it's always written in terms of giving complete control to the insurance company. As in, once the insurance company approves a plan, then the insured is required to follow through on it. But the process of approving a plan almost always will be considered to require the input of a treating doctor. Now, what kinds of things are often available? The most common for medical rehab would be psychological counseling, although getting a personal trainer or getting other types of support may be available to the insured person if the insurance company thinks it will help them get back to work. In terms of vocational rehab, the insurance company may consider things like helping with resume or cover letters or looking at the job market or doing some brief retraining or upgrading, although the insurance companies always put these through a pretty tight cost benefit analysis. So unless they're pretty sure that, you know, that little bit extra will help get the person off the benefit plan or off the benefit payroll, so to speak, you're not going to get it. What are the insured's obligation? The insured is the patient, right? So most disability policies spell out what the insured person has to do to remain eligible for disability benefits. They have to stay under the care of a physician, they have to comply with an approved rehab program, and in some cases they may have to pursue sort of mainstream treatment. Fairly reasonable obligations. Now we move to the second portion of the presentation, which is the different focus between medical profession and insurance company. So I've hazarded to say what the goal for medical intervention is, the provision of medical care for the physical and psychological well-being of the patient. I would say that the goal for insurers is the provision of money for the financial survival and psychological well-being, and the courts have affirmed that that is an important part. The peace of mind is an important part of the contract for disability insurance. Now, the tricky part for insurers is that they're in a conflict, right? If they pay the money out in a disability claim, that's money that they cannot pay to their shareholders as profit. So there's a conflict there that comes into play in relation to disability insurance policies. There's also a different focus in the use of clinical records. Physicians use clinical records to record what's important to them. What's the patient's diagnosis? What's the treatment? What are the changes since the last visit? And you often use the SOAP, Subjective Objective Assessment Plan, kind of approach for recording what's happening. The insurers ask for these records, but what they do is look for something else. They look for what the insured can do, whether he or she can work, whether there is evidence of functional limitations, and whether there is reference to any improvement. And I think the functional limitations would be found under the S and O portions of, you know, the SOAP, and perhaps the improvement under the assessment. So insurance focus, and I want to explore this a little bit further, insurers look for, and the key words here are restrictions and limitations, R and Ls, in function. They try to assess an insurer's ability or the insured's ability to meet the physical demands of the job, which may include sitting, standing, walking, meet the cognitive demands of the job, which can vary considerably from job to job. You know, working at McDonald's and flipping fries or burgers is very different from working in a law office or, you know, in a doctor's office. So the demands of the job is a very important part of what you need to look at if you're dealing with insurance. And meeting the emotional demands of the job. You know, a job where you're not interacting with others versus a job where you've got constantly dealing with angry or frustrated or stressed people or tight deadlines. So those are really important things that the insurance and companies always look for. There's also considerations that it would help for doctors to be aware of, because insurance companies need to be aware of this, around work capacity. To be able to maintain gainful employment, which is really what we are looking at here, most jobs require a person to be able to produce an identified volume of work. You know, you come in, and if you have papers that you have to go through, you expect it to go through that volume of work over a volume period. So you have to do this day after day after day after day, predictably, without missing days. You know, well, I can do it, but I may not be here for whatever days I'm not feeling well. That doesn't usually work very well in a work environment. You have to do it accurately. You can go through the paper, but if half of them are mistakes, that doesn't work. And you have to do it harmoniously. If you go through the paper, but you scream at everybody while you're doing it, that doesn't work. So the work capacity really has to look at, if you're asked to fill out forms around work capacity, you need to look at all of those factors in order to come up with an informed sense of whether a person is able to work. And I guess this graph sort of shows it, right? If you're looking at the graph and the graph is going up and down and all over the place, that's not going to be adequate or acceptable for work. You need to know that the person can consistently meet whatever level the work requires of them in order to be satisfied that they're able to work. And then, of course, and this is not stated a lot, but it's important. The person must have enough mental, physical, and emotional health to be able to function in their personal life, because work is part and a very important part of our life. But if it's all that there is and everything else is falling to pot, then that's not acceptable. So there's a different approach to language. Medical talk, people often say the patient is improved. Insurance talk, the doctors get that patient is improved, and that means the patient can work now, right? The medical often don't refer to restrictions and limitations because that's not what medicine is all about. The insurance companies get that and they go, oh, there's no evidence of restrictions and limitations, the person can work. So these are the areas where I find there is a real clash in how records are used. And if you're aware of it, then maybe you can incorporate or embed some insurance pieces to your notes. How would you do that? Well, if you say, for instance, they're improved from a 2 to 3 out of 10, then we have context. If you say, but still can't do this, that, or the other that might be relevant, you have another piece of information. If you say, but the state fluctuates, so yeah, they're better, but you know, it could go back down again. That's another important piece that you might add. But they're still vulnerable. So yeah, they're getting better, but you know, you load them too heavily and they'll crash. That's another piece that you might want to add in relation to improvement. Or you just simply say, they're not yet ready to work. Now, bald conclusions are not things that insurance companies take to heart as readily as if you list restrictions and limitations. But, you know, these are ways where if you're starting to write improve, think about it and consider whether or not you need to provide some context so that the message will not be that a person can work. So I often think that, you know, the right side of the lens is what our right side, you know, with the castle and everything, is what the doctors think they're writing in their notes. And the left side of the lens is what the insurance companies pull out of it around, you know, their difficulties or whatever. We really have to sort of be aware of what we write if they are going to be used, and they usually are, in an insurance context. Now, different approach to prognosis. So medical talk, doctors love to be optimistic, and it is a wonderful feature. You know, patient improvements mean that you're succeeding in what you're trying to do, right? Patient improvements and patient encouragement means you're helping this patient get better. And so this is a wonderful place to focus on. But when that is what you put in your notes, then the insurers can interpret it as, oh, that means benefits can be terminated. That means the file can be closed. You know, there's another consequence if the file is closed. It means that all of the work of trying to get it back open is transferred to the insured. So this optimism that doctors engage in doesn't always, can have some adverse repercussions for the patients around the insurance piece. Third section of my talk, tackling pain and fatigue. So this, I believe, comes from a Supreme Court of Canada leading decision dealing with pain. This is what the courts say. So their judges are becoming quite aware of how pain can affect people. Pain can interfere with work at a cognitively demanding job and even preclude such work. Pain is very fatiguing, and chronic pain and fatigue commonly occur together. They can prevent a person from concentrating, lead to errors and omissions, and they can be agitating and distracting around work. So those are the kinds of things that it is helpful to be aware of when you translate the fatigue into how it plays out in the workplace. I often find it helpful to consider fatigue in the context of units of energy. So if we take these 3 bottles of marbles, we can pretend that they are the levels of productivity that a person has to perform each day. You have to, you know, fill the bottle with that many marbles in order to be productive. Well, if a person can only fill the bottle with 5 marbles, then they are less productive. And recognizing that, you know, if you do A, then you have less energy to do B. So there's a concrete, you start thinking of fatigue in terms of concrete units of energy. It is sometimes very helpful. Then how many units do you need to have in order to be able to manage your personal life and manage your work life as well? Tackling depression. This is a psychiatrist who wrote this report, and I found it very helpful. It is my opinion that at the present time, Ms. X is too emotionally distressed to engage in any type of employment. Distracted and preoccupied by her worries, can't think clearly or concentrate. She would make numerous mistakes, be readily overwhelmed by demands. Her irritability could easily lead to problems when working, and low energy levels may make it difficult for her to apply herself. So once again, it's this understanding of how depression or emotional problems can really play out in an adverse way in the workplace, and that's something that needs to be taken into consideration. So, tips and strategies. I've got 15 of them. I'll go through them as quickly as I can, and we're almost near the end. So, one thing, learn about your patient's functioning. And these forms, I am incredibly excited by these forms. If you have your patients fill out the forms in advance and you can look at them, you get a ton of information that will help you make better decisions around your patient's functioning. Learn about your patient's jobs. And while, it may be obvious to you what the job is, there are aspects of it that may be really important. Ask, what are the hard parts that you think you would have to do in your job? And if you start getting a sense of that, then you can start matching the capacity with the job demands and seeing whether you've got a match there. So another tip, include references to restrictions and limitations in your notes and contextualize any references to improvement so that when these insurers get the notes, they see examples of restrictions and limitations. If you aren't able to provide an opinion regarding your patient's ability to work, you might suggest that the insurer arrange an IME. Another suggestion, only provide a prognosis, because a prognosis is something in the future, right? If you are fairly confident about what will happen in the future. If you think that it's premature, I invite you to say, this is premature. Ask me again in 1 month, 2 months, 3 months, when you'll know better. Because what happens is if you give an estimate, it's often taken as gospel truth, and then if your estimate is wrong, it's really hard to fix it. So avoid the problem in the first place. If you are asked about a graduated return to work, consider having, and this is not for all cases, but if you've got a complicated situation or where you're worried, have an OT. Get involved and possibly do a worksite assessment to see, well, what is the attitudes of the others? What are the demands? What's the work environment like? Or stating that the graduated return is a trial. We're going to try this, but we need to monitor it and we may need to change it. We might even need to abort it so that it's not considered set in stone, which can happen. Another suggestion, if you have changed your mind about the patient's level of disability, just say it and explain what you think now and why. Because the important thing is to be accurate as you can, and to recognize when there are things that you need to address. If you're writing a report, describe the job demands. I don't often see doctors do that, and that's not what they're trained for. But if you start identifying key portions, you don't have to do the whole thing. The job demands, the restrictions and limitations that they're experiencing, and the difficulties that your patient will likely encounter, in addition to the diagnosis and whatever, then you're talking their language and it starts becoming very powerful. You become a very powerful voice. And what I often tell patients when they call me and they've just been cut off, I say, get a report from a doctor, because nothing I can do in the early stages helps. The insurers, if they're looking at an internal appeal, they want medical information. They don't want lawyers, and you only get me involved when you've tried and it really isn't working. Number 9, if there is insufficient room on these short insurer forms to answer the question, turn over the page and fill it out. Okay, very often the insurers have these short forms, and then they look at them and they say, well, there's not enough information. Well, hello, if you're spending the time to get enough information to give an opinion, and there's not enough room, turn it over and fill it out there, and maybe you can cut it, the problem off at the pass. If you're asked to answer a yes or no, and your real answer is, well, maybe, or depending, or subject to, or consider this, turn over the page and fill it out more. Okay, be true and be accurate to what you consider the situation to be. Don't be governed by the form. 11, if you have a safety concern, state it and propose that it be further investigated or otherwise addressed. The insurance companies have the resources to deal with that. Number 12, if you think your patient is disabled and financially or emotionally vulnerable, state this and express a concern that a denial of benefits could cause your patient to deteriorate and or compromise their recovery. If you're worried about their vulnerability, that is precisely what the law says the insurance plan or the insurance policy is there to address, their peace of mind and their financial survival. If your patient is resisting a treatment option, and often this comes up with medication, and you consider that this is not unreasonable in the circumstances, and I think psychiatrists and research is starting to appreciate that medicine may not be the be-all and end-all in chronic pain, issues, then indicate this in your note. Say discussed medication, patient disinclined to take, I understand, or I accept. That kind of thing will help, because otherwise, if you simply put, discuss medication, patient declines, that sounds as though your patient is not going along with the treatment, and that could expose them to having their benefits terminated. If you have received repeated requests for information from an insurer, please provide us your notes, please provide us your notes, please provide us information, please provide us information. And there's really not a reason to be providing it that frequently. Take some control. Say, I anticipate that you can come back to me in a month or 2 or 3, and we will be in a position to provide you with an update then. If you feel that counseling might make a significant difference, or a personal trainer or whatever else that would help them return to work, then suggest it. An insurer is never obliged to provide that kind of support, but a recommendation from a treating physician could influence the insurer to provide that support. So, much like trying to read a book by its cover, patients are complicated. They have full and complex lives. And when you get into disability insurance, it's worth taking the time to get a sense of who they are, what their jobs are like, and then putting those pieces together. Thank you.
Thank you very much. I'm not sure if the other centers actually can speak now, or they were kind of. I'm sure you can hear us, but if you have any questions, please raise your hand and go ahead. So we'll just take your questions first. I don't see anybody really jumping in to ask any questions, but first of all, I would like to really thank you, Faye, for this very clear presentation, and thank you, Maureen, for this beautiful website that you guys created. I think it's going to be a great help to all of us. I certainly suffered through this patient's case, and tremendously, it's still not resolved. But in any case, any questions from the local audience? Anybody has any?
Well, I had how Faith and I came together one point was I had one patient who had palliative, was offered a third-line treatment. It was ultimately palliative, and she was concerned that she wouldn't get insurance because she was declining medically recommended treatment. So, Faith, do you want to?
Ultimately, the courts and the law look at what makes common sense. So applying that situation, my sense was that if it is palliative, then taking the medication doesn't make the difference between her working and not working, which is what the policy was designed for. And under those circumstances, it would be acceptable for her to decline the medication. What helps, though, a great deal is if the physicians simply state, I understand, I accept. And that way, no judge is going to go past a doctor who says, I get it, it's okay. It's when the doctors say you have to do this and the patient says, I'm not going to, and it will make a difference as to whether they are or are not able to work, that the law comes down pretty hard in requiring the person to undergo the treatment. But in all other respects, I think the court really looks at it, well, will it make a difference in terms of your ability to work?
Another question?
Oh, I have lots of questions.
Yeah, Maureen has lots of questions. I'm just going to say that, how I personally really very much appreciate your clarity about what the problem in the language is and, our perspective to the patients versus insurance perspective to the patients, because that's certainly what I have experienced. And even though I found that my notes were actually abundant in all of these, what you were talking about, it's still a, huge deadlock. And so for various reasons. So my question is like in that patients that I have, like, when do you actually take this to the court? Because he really should be reimbursed. He should get insurance, but he's unable to. And now he is disabled. He can't really work. And, he suffers financially and family suffers. And now he has to take some, insurance company to the court. Like, how is he going to be able to do that? Like, that's really what's mind boggling to me. He doesn't really have the resources. And so here he is, and he's really in disadvantaged position quite significantly.
I recently took a matter to court and argued that the insurance company should pay all of the legal fees where they have wrongly denied benefits and where the legal fees would so diminish the benefits that they would put the person below poverty level. I have no idea whether the courts will be open to that argument, but it is a bit of a passion for me to try to enable people who are wrongly denied to access the courts. So.
Question or clarification. At one point you recommended if a physician has difficulty determining restrictions and limitations that they recommend an independent medical. I would think one step further, saying, for example, I think occupational worksite assessment and occupational therapy, is that considered sort of an independent medical? Because I certainly find that discipline quite helpful.
The relationship between the insurer and the insured is governed by contract. So the contract itself will always allow the insurer to require the insured to undergo a medical examination for purposes of determining whether or not that person is disabled. The origin of that provision is really contemplating an independent medical examination, not a work site evaluation. Having said that, the insurance company can do whatever they wish. They may not want to spend the money to undertake that type of evaluation, but it is always worth asking for it. And if you give credible reasons why you think that is important or valuable, then I think it would be applying some reasonable amount of pressure on them to take that request seriously.